Thank you for staying with the Monday Report. We're still talking about waiting on justice, and we'll get a couple of questions from our audience here. But first, I'll come to you, Kakai. How does the judiciary prioritize cases? Because we've seen certain cases like election petitions, for example, go through really fast. What are the merits? How do they prioritize the cases?
When it comes to issues of giving priority to cases, cases basically are divided into three categories. One is the election petition. When it comes to election petition, this is a very specialized area of practice where rules have been developed. And where, therefore, when there's an election petition, there are rules that are developed within which an election petition must be had and completed, because it's touching on representation of people, which has been a shift from the past where we will have an election petition. An election petition is done almost 5 years. By the time an award or a judgment is being done, the area MP, who'd never won, actually has finished his term. You remember the case of Malava, the famous case of Malava, where Joshua Ngatia lost an election petition after his term was over. So then over the years, the rules have been developed and said, look, the best way to do, because it's representing people and people want proper representation, let's have rules and regulations in which you govern an election petition. So there are timelines that are normally set in which, like normally 6 months, in which a petition must be heard and determined.
So shouldn't there be timelines set for other cases as well?
And I'm coming to that. For the case of presidential election petition, you know very well the Constitution talks about 14 days and everything must be done. So that is a governance structure that has been established over election petitions. Now, when it comes to criminal cases, because the cases are different. When it comes to criminal cases, there are no specific timelines that have been set in terms of how to determine that a criminal case.
Should there be timelines?
Yes, I'm coming to that, because the actors are so many. It becomes more complex. Different institutions are dealing with different actors. There's the police, there's the DPP, there are lawyers involved, and there's also the institution in terms of the judiciary. But there are no timelines set. Whether there should be timelines set or not is a question that now lawyers, and I wish that Harriet, since she's leading the Law Society of Kenya, should tell us whether it's necessary to have a timeline set in criminal proceedings.
Okay. All right, I'll come to you, Harriet. But Okia, you've been a lot at the corridors of justice. How have you managed to navigate the system and get your cases heard?
Well, there are several cases, there are several issues, and I think in terms of the time it takes to determine a case, one, you'll find that if you look at the average cost list of a judge, I wouldn't even touch the magistrates, because what the magistrates do is like magic, because they have got so many cases, you wonder how they even manage it. But I'll take an example of a judge. You'll find a judge has got so many cases in a day that it will require quite a bit of time for him to go through the cases and maybe listen, go and write judgment and stuff. So I think one thing is there is manpower. There's a major manpower shortage, and that goes to Parliament, which is supposed to facilitate the judiciary. Parliament should allocate funds and enable more judges to be appointed, so that you can ease the job. Like if you got the land courts now in Nairobi, if you went to file a case today, even under certificate of urgency, the earliest we might get a hearing is next year. Not this year, it will be next year.
And that's under certificate of urgency?
Yes, under certificate of urgency, and that's how bad matters are, because the judges are overworked. Then number two, you have the advocates and their clients. Sometimes clients are difficult for advocates to get them to give them their pleading or their side of the story or things like those, or there are fees involved. So you'll find that sometimes a judge says, okay, come, we'll hear this matter on such and such a date. The judge comes prepared, he sits. Then one of the advocates of one of the parties said he's not ready to proceed. And that's something, if you sit in our courts on a daily basis, you'll see it happening with a lot of frequency, to a point whereby you'll see that sometimes a judge will go away without hearing any case, because all the parties who came, none of them was ready to proceed.
But was that deliberate then? It's a deliberate
Whether it's deliberate or not, I don't know, but it's a factor that contributes to the delay. What I know is that it contributes to the delay, and so those kind of things happen. And so I think it requires a holistic undertaking. And also when you look at the way judges proceed, they do notes, the analog way. There was a time we had seen some gadgets being installed, and even we thought that we were going to have stenographers and things like those.
Even recently, the CJ said by September they'll digitize the system.
Yes, so we need to have those kind of things in place. It will also help. One thing is that when the judge takes notes, so you don't know whether the judge has a hearing problem or the judge has heard you well. Sometimes we come from different backgrounds, and the judge may be from an area where the words sound differently, the sounds are different. So the judge may be taking notes that are erroneous. So there's no mechanism whereby after hearing the parties, the judge says, can you look at my notes and maybe countersign?
Yeah.
And yet that's what's going to bind the parties. So if we had to have people taking these things digitally and what have you, it will help so that if there's any dispute on how the proceedings went, when you get a record of the proceedings, it's accurate. Okay. So there are very many factors which are administrative, human resource, and also legislative framework, because I know that I think petitions are supposed to be disposed of in 90 days or something. There's something like that somewhere I've seen, that a petition when you file should take you 90 days. But I told like mine took me 8.5 years, the one you just referred to. So all those things are done. Then this kind of, if it's 90 days, let there be enough manpower to deal with the 90, to ensure it's 90 days. And then we can maybe develop the practice of going by that time. But I think it's important, and especially as it is said that justice delayed is justice denied. So it's very, very important that we get to a point whereby matters are disposed of in real time. And quickly.
Harriet, I'll come to you in just a bit, but for now, Mashirima, there are questions from the audience.
Naam, kabla ya kwenda kwa wale ambao wako hapa, hili swali ni la Harriet. Paul Gikuhi Moya amekuwa akitazama na anasema there was a case of retired teachers 1997 ambao tuliwataja tulipoanza kipindi hiki. Anasema but the government is yet to pay their dues. Why? Yet many have died and others are struggling. My father is a victim and I can attest to the difficulties he is still going through. They are now aging with illnesses and challenges. They are begging their struggling kids for support. Can LSK also pick up this case and push the AG or whomever is sitting on their ward? Harriet.
All right, thank you very much. First, what is coming out clearly is that most Kenyans actually are not aware of the systems which have been put in place and what other steps they can take as and when they reach a hurdle. And even as we speak right now, the best I can tell any of those parties who feel that they are stuck, it takes one step. For instance, notify the next institution. So why can't they write to the LSK, and then the Law Society of Kenya can then pick it up on their behalf? Because our members are lawyers, and we can also find ways of following up those matters. That is one. Number two, it's also the issue of, I can comment on the issues of the delays in the justice system, which Okiya Omtata has brought out very well, the issues that bring out these delays within the wheels of justice. And just like we have already enumerated, is that the wheels of justice is a circular kind of trajectory in terms of delivery of the justice system. First, you start with the investigations in terms of the criminal processes. If investigations are done properly, I can assure you, parties will have it easy within the corridors of justice. If investigations are not done properly, then the lawyers come in to identify the gaps to win cases for their clients. And I like what Wilson has brought out. He's brought it out very clearly that it's not one institution that can be blamed. It's various factors that lead to certain issues and failures within the justice system.
But shouldn't the same impetus be applied to other cases as well, the same ones that has been applied to election petitions? Because if that can be pulled off and it also involves a lot of investigations, why not the rest?
Let me point out one case, and it has been brought out also very well that you find a situation whereby you have clients who are litigious. Remember, lawyers also receive instructions from their clients. You can advise a client, but the client can choose not to take up your advice. What will they do next? Move to the next lawyer. What happens? The process starts. This lawyer has to study the case. This lawyer has to now bring these issues out in court. For you start now putting other applications in place. So you cannot blame one individual, and you cannot use one case as a litmus to test all the other failures within the wheels of justice. And that is just what we are trying to bring out, because it will be very difficult. It will be nice to set the parameters, but it will be very difficult to say a particular, like murder cases, it will be very difficult to say this case has to take 3 months, 6 months. It is also almost impossible, because once you start a case, you'll meet hurdles along the way. Once you start a case, if it was not properly investigated, you'll find there are gaps that you have to try and, work around when these cases are still going on. Okay. If the investigation is not done properly, you find these files are still being taken back to the investigating officers, and many other things, including corruption within the wheels of justice system. Okay. So that is why we are saying it's about the moral fabric. It takes me back to that. Yeah. It takes me back to that. Okay. And it affects each and every institution that is charged with delivery of justice within the social
legal
setup.
System. All right.
Yeah.
Shirima?
Naam, hebu sasa tuangazie kesi zingine ambazo zimekuwa zikitajwa mara kwa mara, ambapo kuna wakati mmoja ambapo kulikuwa na mama aliwaacha watoto mahakamani kwa sababu alihisi kuwa kesi yake kuhusiana na ardhi ilichukua muda mrefu. Kuna wawili hapa ambao watakuwa wanatueleza visa vyao. Daniel.
Shukran Mashirima Kapombe. Kwa majina ni Daniel Omwaga, mwanafunzi chuo kikuu cha Nairobi, somo la uandishi. Ni wazi kwamba sekta ya idara ya mahakama nchini Kenya imeendelea sana katika kufanya maamuzi yake. Kwa vile tunaona kwamba wasimamizi wale huwa wanakita macho sana kwa zile koti za juu, mfano ile High Court na Court of Appeal. Kusahau kwamba kule chini kuna zile subordinate courts, ni zile ambazo zile kama mfano tu the Cadi courts na zile martial courts. Huku chini kuna kesi kadha wa kadha ambazo zimejaa kule na bado hazijatatuliwa kwa takriban miaka 20, na labda kwa mfano mwaka 2016 babangu mzazi alipofariki, kisha akatuacha na kesi fulani ya shamba ambayo alikuwa ashalimiliki. Kisha kukatokea kama kuna mwanasiasa mmoja kutoka ile sehemu ya kule nyumbani ambaye alitaka kwamba anasema kwamba kipande hicho cha land kilikuwa ni chake. So ikatokea kwamba miaka kwa mwaka mama anaenda kule kotini kufuatilia kesi hiyo, lakini hakuna suluhisho yoyote ile. Manake yule ambaye aliyekuwa anatupinga ni mtu fulani mwenye nguvu, nasema kwa mfano ni mwenye hela. So inasemekana kwamba haezi endelea na kesi ile, inabaki tu iko huko. Huku ukijaribu kuangalia kuna kesi kadha wa kadha 500 na ambazo hazijaruhusiwa.
Naam. Asante Daniel. Labda tumpatie Masi Otieno naye nafasi aweze kutueleza, wewe rafiki yako amekuwa na kesi sawia na hiyo, imechukua muda gani kesi ya ardhi?
Asante sana Mashirima. Kwa majina naitwa Masi Otieno, mfanyabiashara Nairobi. Kuna rafiki yangu mama mjane amewahi kuwa na kesi mahakamani kuhusu shamba kwa miaka kama 5 saa hizi, lakini baada ya kujafikia maamuzi, ndio sasa nauliza mbona ichukue muda mrefu hivyo. Mama amekuwa akienda mara faili imepotea, akienda anarudi mara baada ya kujamuliwa. Ndio nauliza ni je, mpaka lini wananchi wataendelea kuteseka kungojea haki zitendeke?
Na Trevor, katika kisa hicho kuhusiana na kesi za ardhi na kesi zingine pia ambazo zinahusu familia, kulikuwa na wakati ambapo idara ya mahakama ilizindua swala la upatanisho au mediation ukipenda. Ni kesi zipi ambazo zinaweza kutatuliwa kwa njia hiyo ili kuweza kupunguza ule mrundiko wa kesi katika zile ambazo ziko mahakamani?
Madam Harriet, and I think you can start with that because there's the issue that Mashirima is raising, the ADR, Alternative Dispute Resolution. And like you've clearly heard, there's several cases that take so long in the justice system, people almost give up. And then there's also another question from Mary here. She says, ask Madam Vice, why are court orders given by the courts and not being obeyed? What action can be taken against institutions that don't obey court orders?
All right. First, I'm glad that she's actually taken note of that. And it's quite unfortunate that we disobey court orders. Once upon a time, I sat in one of these forums and they said, if there's any institutions that all Kenyans should defend with whatever it is they can, is the judiciary. Court orders must be obeyed. It doesn't matter by who. So it's important that court orders are obeyed.
I think there's no action that the court can take, because then we've seen court orders being disobeyed or just being ignored.
Well, there is action. You can issue warrant of arrests, you know, but the question then is, who are these who are disobeying these court orders, and who are going to effect the warrants of arrest, and to what extent? But you've seen currently there's a lot of movement in terms of what is happening within the societal framework. Yeah. And for us, we still have hope that we are going to defend the judiciary, the independence of the judiciary. And it's important that all Kenyans do obey these court orders. That is one. Two, in terms of ADR and mediation, quite a number of cases that we have in court, which are contributing to the bulk of the court cases that we have, should actually go through the process of mediation and ADR. And most of these cases, family matters, issues to do with land, you know, issues to do with the children cases, you know. These are cases that ordinarily, it's issues to do with disagreements and conflicts amongst people within the society, people who know each other, yeah, family members, you know. These are things that if you sit down, you can actually agree. Yeah. And one thing I want to tell Kenyans is that it's not any advocate's joy that matters take long in court. Actually, any court, any legal process that takes so long is very expensive to any litigant. It becomes so expensive that you end up spending so much of your time and money in these particular cases. Yeah. So it will be the joy of lawyers that they also have an opportunity to dispense of their matters very fast. You know, the delays, you can imagine the amount of time you put in a case that has been in court for, let's say, 12, 15 years. And let me quantify that and say that maybe the advocates who are handling that case, yeah, maybe what they charged within 15, 12 years is maybe 150,000.
So how do we fix that system then and make it faster? Because so we seem to be agreeing that there's delays. So how do we make it faster?
There's a lot that can be done. One, we need to remove some of these cases from the litigious process of the courts by going through the ADR and mediation processes. Yeah. Number two, automation of our court processes. Yeah. I must also say automation is not 100% solution, yeah, because garbage in, garbage out, number one. Two, the automated systems are actually operated by the human beings. Yeah. So automating alone is not a magic wand for quick processing of court matters. It also goes back to the moral fabric. Are we disciplined enough to be able to process this system? Okay. Are we disciplined enough to be able to operate these systems within the confines and the time frames and the indicators that we've been given to be able for us to operate these systems and for them to conclude these matters, or for our processes to be smooth. Two, yeah, it's also a good plus, three, it's a good plus in terms of the systems, because yeah, once you automate the court processes, you'll have quick payments. Yeah. The long queues at the registries will reduce. Disappearance of court files will also reduce, because you can save these files within the e-platform, yeah, in different levels. You can have the cloud system, you can have the, you can localize the system by having the servers, and you can have various backups. So even if a file disappears, yeah, then you can always retrieve it. Okay. Yeah.
We have to take a quick break here, but when we come back, I'd like to hear from Okia that we know all these solutions, we have them, but how come they're not being implemented? What is the missing link? But before that, we're going to take a quick break. Keep your feedback coming. Use the hashtag Monday Report. We are back in just a bit.